Our next speaker is Mr. Ravi Bhola, the patent chair of KNS Partners. He is a biotechnologist and a lawyer, and his main focus areas are patents and designs. Mr. Bhola is a certified patent valuation analyst and enjoys working with startups. He is also a member of the IPR committees of FICCI and CII. Today, he will be talking on IP and startups. Sir, if you could please take over.
Yeah, thank you so much, and very good afternoon to all of you. I just want to check, can I share my slide deck at this stage?
Yes, sir. Please give me a second.
Yeah.
So you should be able to share your slides now.
Yeah, I'm just trying to open that file. Just give me a second. Can you see my slide deck?
Not yet, sir. I
Not
think
yet.
just give me a second,
Okay,
sir.
just let me see if I can share it differently. Just 1 second.
So is the share option open to you?
Yeah, I could see the share option, and I'm trying to. Just give me a second. Can you see it now?
Yes, sir. It is visible now.
All right. All right. Thank you so much. So very good afternoon to all of you, and a big thank you to Dr. Anindya Sirkar and to Nalsar for the opportunity to interact with you and present my thoughts. And I'm going to talk about IP and startups. Very quickly, I'm just trying to. Yeah, so very quickly about the firm I represent. It is K&S Partners. We're around for 25 years, pure play in the area of IP, 6 offices across the country, and with about 275 people, one of the largest IP firms in the country. Now, since I'm going to talk about the startups, maybe very quickly I'll give you the kind of criteria that is used for a company to qualify as a startup. A startup in India which meets all these 4 requirements will be able to avail different set of benefits that are available for startups, be it in terms of fast tracking of patents or to pay reduced government fee to obtain IP. So if you're set up as a young company within last 10 years and during your term of existence in no financial year, you had a turnover of more than 100 crore, you're not a spin-off or not being split off from a large size existing company, and if your focus is primarily on R&D, then you qualify as a startup and able to avail various benefits that are available for startups in India. In terms of timelines, what I have seen for companies when they are trying to acquire IP, these are typical timelines I see in India. Typically for patents, for startups, it takes just about a year, which is considerably lesser amount of time as compared to what generally it takes in India to get a patent in India. And I've seen that even in some of the developed jurisdictions like US, Europe, Australia, Canada, it does take around 3 years or so to get a patent. So it's absolutely fantastic that in India, we are not only able to have the patent rules which provide for fast tracking patents for startups, but also have the operational framework to make it happen on ground. Trademarks can take 1 to 2 years depending upon, you have hearings, if at all, or a third party representation. Copyright generally takes about 7-8 months. Designs has become pretty fast now, about 4 months to get registration. So overall, if you think of it in terms of timelines to get IP in India, especially from patent perspective, it's absolutely extraordinary. In fact, a lot of developed jurisdiction in the world also are generally not able to get you patents for startups in a year's time, and it is so critical in that sense. Now, based on my experience of having worked with probably more than 200 startups in last 20 years, there are a few pointers I would like to share with you. The typical situations that I have seen startups, get into. the challenges that I have often seen startups face when they're trying to build IP portfolio and maintain IP portfolio, and what kind of priorities they need to set around IP. One common challenge that I see often, for young companies and startups is that the founders are trying to dabble with a lot of things. Okay, they're trying to build a team, they're trying to raise capital, they're trying to create a product which can differentiate in the marketplace, and therefore, while as young companies, as startups, they have a lot of good ideas, a lot of good IP which is floating around, but they don't often have a good framework in place to flag that IP, document that IP, um, file for registration for that IP, and maintain that IP. So that those kind of processes and framework are often not available in startup kind of an ecosystem, because it's a small team trying to dabble with different things. But often these startups with time realize that when they're trying to raise more capital, what investors are looking for is not only that you're able to build a good team. Of course, it's very important, but whether you are able to file and timely file IP for the product that you're trying to develop or the technology that you want to offer as a service. And that itself can often become be a cause of a deal breaker, where investors, for example, may shy away from investing in such companies. So it's important that while you may have great ideas, timing is critical. For almost all the kinds of IPs that we see in the world, the party who files for IP first gets everything, right? Typically in patents, two different groups might be working on the same piece of technology. Let's say one in Japan, one in US, but the one who files it first, is the winner. So it's winner who takes it all. The guy who files it second gets nothing. Therefore, timely filing of IP is critical for everyone, particularly for young companies and startups when they don't have very many processes or established SOPs in place. So that's critical in my view. Another element which I often see is that the IP that you may have developed and filed for, who really owns that IP? The company may think, hey, it was done in my lab, so I own the IP. But the question that can often be asked is that, do you have an employment contract in place where clearly the IP is assigned to the company or the startup? What if you're working with different set of contractors, third parties to give you components? Do they own the IP for what they have developed as a component that goes into your device, for example? Or will it be a joint IP with such contractors? So we often come across situations where there's an assumption that, if I am the company, I own the IP, but then strictly legally speaking, there could be issues. I mean, I still remember, a few years ago, I had an experience in a case where, um, for example, ISC in Bangalore, they run various PhD programs. So they have running this PhD program in the area of semiconductors. And one PhD scholar was actually an employee of a semiconductor company and had taken a sabbatical from semiconductor company to pursue his PhD, sponsored by the company. All right. And his employment contract with the company said, all through his term of contract, wherever he might be, as long as he's on the company's rolls, anything that he develops is exclusively owned by that company. But then this guy was working as a research scholar at ISC and developing IP, which the professor in the lab felt is owned by his lab and by the institution. So these kind of conflicting situations can emerge. So therefore, it's important to have a clarity in terms of who owns the IP. That's again, it's important. So you have to have an IP clause, for example, as a startup in your contract, to make sure that anything developed by your employees, contractors, the business partners is owned by you, or whatever that mutually is agreed upon. I have also seen, when investors are looking at investing in the companies, they also want to see that the IP is owned by the company and not really necessarily by employees or third parties and things like that, because it limits the ability of the company to operate and take decisions on IP in future. Another element which I often see, is about the inventorship in the cases of patents. As you might know that when you file for a patent, you are not only required to disclose who the applicant or the owner of that patent is or application is, but also who are those people, individuals who have developed that piece of technology for which patent is sought. Now, I have seen extremes of situations in such cases. In some cases, I have seen that uh, yeah, in some cases, what I have seen is that the company, a startup, would put the name of the founder in all the patents that are filed. So there was this startup which was well funded. They filed for dozens of patents on diverse areas of technology, and they had the same one person, the founder, as the inventor for all their cases. And it can be a very strange situation, because um, the question is that inventor is someone who has creatively contributed to the idea. Just because someone has executed another person's idea, then the person who has executed it does not necessarily qualify to become an inventor. So therefore, it's important for us to have a clarity in terms of who the inventor is. It could also mean several obligations that those inventors may have going forward. It could also mean several obligations the applicant or the company may have towards the inventor. So as you can imagine, I mean, typically in a country like Germany, as many of us know, the constitution in Germany provides for a benefit sharing or a royalty sharing arrangement that a company needs to have with the inventors once the technology is incorporated into a product and the product is sold in the marketplace. So company has constitutional obligation to financially reward the inventor if the technology hits the market. Now that is not necessarily the case right now in India, but things can change with time. So therefore, clarity in terms of who will qualify as an inventor and who would not is critical. I've also seen another extreme where, especially in research institutions, I have seen, um, you know, 10, 15, 20 people are listed as inventors. Just because some people may believe it gives them the recognition, but that again is not the correct consideration to identify people who will qualify as inventors. So it's important to have a good system and processes in place for such startups to make sure that the right kind of people who have actually contributed to the idea are the ones who are identified as inventors. Another important thing, from patent perspective is that when you are putting together a patent specification, what all should go into a patent specification and what all should not go into a patent specification. So patent specification is a document. It is a technical document as well as a legal document where the inventor or the applicant, the company, is required to clearly in detail explain what the invention is. Because unless you disclose what the invention is, you will not be able to enjoy monopoly or a patent over that piece of technology. Now the catch is, if you disclose too much, more than what is required, then you end up disclosing a lot of information which could have been retained as a trade secret or a technology know-how. Now, every patent application is published, as you know, which means your competitors also get to read the patent specification, and they can get to know about a lot of things which were not necessarily required to be disclosed by you in the patent specification. So obviously you have put your own company at a disadvantageous position by letting your competitors know a lot about specific technology know-how. I'll give you an example. So let's say I have a patent, or I'm seeking a patent for a process. And a process parameters could be, I'll use temperature in a certain range, maybe pressure at a certain range, and those are the ranges I'll give. Now, I might have some indication that maybe a particular value within that temperature range might actually give ideal result, optimal result. The question is, do I need to necessarily provide that information? I may have not tested it, but I assume it might be an ideal or optimal temperature. That's in a range of 27 to 37 degrees centigrade. I know maybe 31 has a chance to be the optimal. Do I need to necessarily give that information in the patent specification? There are some of these are debatable issues, but the point I'm trying to make is that you need to disclose only so much information which is required for you to get the patent. At the same time, you can't give too little information, because if you give very limited information, the patent office who is going to examine your case will not be able to comprehend how exactly you will be able to arrive at the invention. Because by reading your patent specification, anyone in that domain with a person of average skill, by reading your patent specification, should be able to broadly perform the invention. But if the information given is inadequate, he or she will not be able to perform the invention, and therefore your patent application can be rejected for not meeting the requirement of enablement. Okay, so the point here is, how do you strike that fine balance to make the right amount and the right kind of disclosure, so you do get a patent but not end up disclosing information a lot more than what you were required to do? Because often the strategy could be, your IP strategy could be some monopoly by way of patent, some information you keep trade secret so that your competitors don't get to know everything that you do in your lab or in the facilities. So that's another element which I feel, as startups, I sometimes find them struggling there. Honestly, it's not limiting to only startups, but generally startups, when they are, the early stage of their existence, they struggle with this. I've seen some companies, young companies, putting the details similar to the way the disclosure has to be made in a scientific journal for publishing an article in a scientific journal. That kind of detailing in terms of experimentation is not really required from patent perspective. So that kind of differentiation should be clear to us. Another element which I believe is again very important, and often companies struggle, is that you may need to seek a multi-layer protection for your invention, because a single layer of protection may be inadequate. So what, often people give a typical example of Gillette, razor. And, we all know that the company Gillette, which is now owned by P&G, uh, they have tons of patents filed around that single razor. Of course, there are variants of that razor, but for different aspects of the razors, different patents have been filed. One, for example, could be the kind of spacing which is required between the blades. One patent could be for the angle or the inclination at which those blades are placed. One could be on the grip around the razor. One could be around the material used for making that razor, and things like that. So what they try to do is, they have a multi-layer protection for the device, so that they are able to raise the threshold for any competitor to copy the product. So even if one patent expires after 20 years, there's another patent which is available to provide exclusivity to Gillette for that razor. And when you have, along with that, maybe some design protection apart from patent, you may have some sort of a branding and trademark protection around that article, and you do a whole lot of things around it. So it becomes so difficult for a competitor to get into your space, or develop a product similar to that of yours. Here another example which I have put in the slides is like a typical medical device you may have. It will have a technology element. Let's say it's diagnosing certain disease condition, or it has multi, or maybe it has a microfluidic arrangement. It will have some chip sitting there. It might be doing some PCR test. So there are technical scientific elements involved for which a patent can be obtained. You can have design protection for the aesthetic look of the article, how nice the article looks, it appeals to the eye, and then some branding around it, some name you give to that brand or the device. So that's how you try to create multiple layers around that core product, so that you are able to protect your product from infringement. And if at all there's an infringement, then you have enough ammunition to go after the infringer. So this is how multi-layer protection helps. Sometimes young companies, startups struggle because of liquidity issues. They may not have that kind of monies at the initial stage of their existence to invest in all this. And so therefore there are different ways and means in which you can stagger your expenditure without compromising on degree or scope of protection you should get for your IP. So things like, you can, for example, we talk about a PCT application. Maybe some of the other fellow speakers may have covered it, but you file a PCT application, which gives you, a breathing time of 2.5 years. And in those 2.5 years, you try to scale up, raise more capital so that you can then cover other additional countries, let's say beyond India, based on how your business is going. As you know, because patent rights, a lot of these rights are all country specific rights. And if you are seeking patent in multiple countries, for example, in one go, if you're doing it, then you have to have the kind of budgets to do this. So maybe staggering it, having a strategy in place does help you manage your resources well, and at the same time able to cover the key markets which are of commercial interest to you. Then this is related to what I was just mentioning. Typically, again, what I see for startups is they leverage different geographies for different purposes. So I, as a startup sitting in Bangalore, I may do R&D here in India. I may then do my manufacturing in China. My market is US. And then my market is Southeast Asia, but I know it will be routed through Singapore as a channel. So I need to have a proper clarity in terms of which are the countries are important to me, both as markets or as manufacturing hubs or R&D facilities, because these are the areas where stakes are high for me. So these are the jurisdictions where I should get patent protection or IP protection so that I can stop infringement. Typically, as um, you know, the infringement can happen. For example, some of the ex-employees, let's say the startup, move on and then they start doing something. So they could be in the same country where R&D is happening. You have to have protection to stop such things to happen from happening. You're manufacturing it in China, then there could be challenges in terms of, another local player manufacturing it, or maybe the party to whom you have given the contract for manufacturing, that party itself might also make some extra units and release it in the market or export it to US without your consent, without letting you know about it. And of course, in US, if a similar product hits the market, then again, your patent has been infringed. So you have to have a clarity as a young company in terms of which are the countries where I should seek a patent. How do I plan it so that I'm able to manage my resources well? I have seen young companies when they approach investors, especially for series B and C, I have seen them, investors saying, hey, your product is great, you build a great team, you have good revenue stream, but if you had a patent in Europe, we could have been able to sell a lot more. Right now, because you don't have a patent, hence others can liberally copy, and Europe is a big market. There are 40 countries there. I wish you had filed a patent there. Now these are the conversations that we often see between investors and the young companies, especially when they are expanding, and have been able to have a proof of concept revenue coming in, but expanding to other territories. So therefore, things like PCT, the Patent Cooperation Treaty, which I briefly touched upon earlier, are the treaties where several countries are members of that treaty. Almost 100 and I think 160, 70 countries are members of that treaty. And then what happens within 2.5 years from the filing of the PCT application, you can enter into any of those countries and you still enjoy the priority date of your first application, which you may have filed, for example, in India. So you have to, or similarly, I have seen for some kind of inventions where Africa is a market. Now you can have a single application filed to cover 12 countries or 13 countries in Africa by way of a repo. You can have a GCC patent application filed to cover 6 countries in the Middle East. Or you can have a single application filed in Europe to cover 35, 40 countries. So there are tools available to facilitate it. It's just that startups and young companies need to know that such kind of tools are available for them to cost effectively build their patent portfolio. Now, often this is something again that often comes up in the conversation with young companies and startups. Once they're able to, let's say, file a patent and get the patent in, let's say, a year, 2 years time, and now they believe because they've got a patent, they're free to go ahead and use it, and nobody can stop them in the country. Now, as we know, patents are all country specific, so there again it's important. If you have a patent in India, you have monopoly in India. If you don't have patent, let's say in Bangladesh, then it means it's free for everyone to use it, and you can't stop them from using your technology in Bangladesh. Now, freedom to operate comes in where, let's say, you have got a patent, let's say for a device. Let's say you got a patent for a handheld, some device for, let's say, detecting a disease condition, let's say hepatitis C. Now, the device will have some chip sitting there, will have some other component sitting there. Now, think of it. Your patent is for the device, entire device. But the chip in your device is somebody else's patent. Now, how can you make your product, the entire device, if one of the components in your device, that is chip, is somebody else's IP? Which means either you have to take a license from that party, or you have to buy that chip from the market, which is through that supplier who owns the IP. Then only you can arrive at your product. It means while you have a patent for the device as a whole, but you don't have the freedom to operate on your own patent, because you cannot get your patent without infringing somebody else's patent. Now, to avoid infringement, you need to take a license, or you have to then look at some other kind of a chip so that you don't infringe that party's chip. So therefore, it's important to have a clarity that apart from getting a patent, you also have to be mindful that you have the freedom to operate to sell the product in the market. Now, one more thing which I have often seen is that as companies, some startups, it's not with every startup, but some startups that are particularly able to raise some capital at the very early stage of their existence, they will go and try to build a pretty large size patent portfolio or IP portfolio. They'll file patents left, right, center in all kinds of countries, because we also know that when the valuation happens of the company, the investors sometimes think that a large size portfolio means a strong IP, and therefore the companies are valued higher. The IP portfolio is also valued higher. But with time, we all have learned that while size is important, but what really matters is the quality. The quality of patents is more critical. I have seen deals where a small patent portfolio of 6 patents is being licensed out in a deal of almost 65 million USD. Just think of it. And I've also seen transactions where, you know, a large size portfolio of 200 plus patents, you know, could really actually get the value of almost even a crore or 2 crore. So its numbers do help to some extent, but beyond a point, it is not necessarily a number game for patents and IP. What really matters is the quality of IP that you own. And therefore, it's important to strike that nice balance between the two, so that you have a portfolio which is a viable long-term tool as a part of your business strategy. Otherwise, it will just end up being a white elephant, which, as you know, means that, you know, every year you have to pay large amount of annuity fee and maintenance fee to keep that portfolio alive, while this portfolio is not really giving you any meaningful advantage or differentiation. So it's wise to use your resources judiciously when you are building an IP portfolio. So this is what I had, you know, for the presentation today. I believe we still have some time, and we'll be happy to take any questions from the audience. I'll stop sharing. I'm just thinking, how do I stop sharing this? Um, Kaji, can you help me? How do I stop? There
Thank
it
you
is.
so much.
Sorry.
Yes,
God,
uh, I have told the team to take care of it, so you don't have to worry.
okay, all
So,
right.
yes, there is one question ready for you, sir.
Mm,
So, in your slide in the beginning, you had mentioned that the patent term is for 10 years for startups. So, there's a question from Rakesh Kumar who says that startups should not be older than 5 years as per the patent rule, but in your slide it is 10. Can you please tell the amendment?
yeah, there's nothing in the patent rule per se which talks about the qualification. It is driven by the rules which are released by DPIIT. And as far as my recollection is that it's been 10 years for the startups to leverage all the benefits under the IP. Earlier, there was so earlier it was 10 years only for, I think 10 years, it was earlier 10 years for either only life science companies or something like that. But 3-4 years ago, that was also changed. So now today, cut across technology domains, it is 10 years for everyone. Yeah. Any other question do we have, Khaja here? Yeah.
Thank you so much for answering that, sir. I'm trying to look through the chat if there's any other questions, but I don't see anything. So
Okay.
I request the attendees that if they have any questions, this will be the right time to drop in your questions either in the chat box or in the Q&A section. We'll just wait for a couple of minutes, sir,
Sure.
and then you can give your concluding remarks.
Sure.
Uh,
I'm just
Mr.
wondering, you know,
Ravi,
in the
can I ask
previous
a
session.
question?
Yeah. Sir.
See, you said, how can we increase, the awareness of uh, utilizing and protecting IP in the startup? We find there's a lot of reluctance until the VC comes in. So,
Mm-hmm.
do you see some ways how we can improve it? Would like to have your thoughts on those.
Yeah. So you're right, sir, that, you know, often I have seen that some startups, particularly the ones who have not gone through one or two cycles in the past, you know, a lot depends upon the background of the founders. If they are serial entrepreneurs, I think they have generally a lot of awareness around IP because they've gone through the rigor. But you know, the very young founders or co-founders, uh, I think they struggle in the beginning to understand, you know, what all value IP can bring in. And you're right that it's only when there's a bit of a nudging from the investors, and when they have to showcase what they have built over the last few years, is when the IP gets some attention. And in my view, I think, you know, a lot of these programs which have been run by the government, state government, and the central government are important. Now, if you think of it, one of the reasons which puts off the founders to invest in IP is that, you know, IP can be an expensive IP building can be an expensive proposition, especially on the patent side. Now, I have seen, a lot of solid founders have no idea the government has got several programs running to reimburse the IP expense. Right now, actually, I'm sitting here at CCamp and just now met with some 7-8 exciting startups, in the first half today. And a lot of them had no idea that, for example, MIT in the electronic semiconductor software space offers reimbursement of as much as 15 lakh rupees to startups, once they are able to file IP. So I think a lot of this resistance comes because of the capital requirement. So more awareness around this, which institutions like TIFEC is doing, institutions like NRDC is doing, several institutions like CSIR are doing, or, things what TIE, for example, the Indus Entrepreneur Group does, things which ABLE and different industry bodies do, CII, FICCI do. I think more and more awareness around it is the key. And what I've also seen is that now with IP becoming a kind of a part of the curriculum, and sir, you are yourself involved in developing a lot of those curriculum for universities and other places. I think those are the important steps, because during my school and college days, if I'm exposed to some of it, it'll come naturally to me. So that's what I have experienced. Yeah.
One last thing, C Camp is a much better place.
Yes. But
C
here
Camp
again,
has
you have
no,
the same challenge.
it's far more educated aware than many others. Okay.
True.
And, but I'm talking of the unorganized, startups.
Yeah. Yeah. No, it's a challenge. And honestly, if you think of it, if I have started a young company and I have limited capital, honestly, my first priority is to keep my company afloat, right? Which also means that I should be able to pay basic salaries to my few employees that I may have, and run my own house also. you know so when they deal with, and of course they have to develop the product and the technology, so I think a lot of it is driven by those constraints, liquidity constraints. It might not necessarily be only the awareness part of it. So I think it has a mix of liquidity issue and also the time constraint. Founders do multitasking. I think they enjoy that hustle and bustle of it, but I think that's where somehow IP doesn't get due attention. Also, I think as a country, I feel we have not done enough to showcase the successes in the country on IP. We have a lot of successes, startup ecosystem, academia, research institutions, a lot of success stories. We have to present them, give platform for such people to share their success stories. I mean, I remember the spin-off that, Dr. Sudhanshu Vruti created from NII, 15 years ago. Such a big success. The DG of CSIR started a small company out of his product through, I think, PGI Chandigarh or somewhere, Imtech in Chandigarh. Similarly, Rajiv Gandhi Center for Biotechnology in Kerala. Spin-offs coming out, young companies doing so well, leveraging IP, making big monies based on IP. I think they need to have more platform. Right now, I think a lot of visibility is given to, e-commerce and those kind of, unicorns. And honestly, they don't necessarily have big IP portfolio. So it's also in terms of messaging becomes a bit of a challenge. But I think showcasing more success stories is also a possible way forward. Yeah.
I can't agree more with you. But I feel the biggest example out there from the city where both of us come from is transgenomics. How Professor
Yes.
Vijay Chandra from Indian Institute of Science took a
Absolutely.
sabbatical, came out, and formed a billion-dollar company.
Absolutely, absolutely. And I'm glad you talked about it, because you know I I still remember it. The picture was published in this science magazine used to called Science Reporter, if you recall, and they had this beautiful article on these four people from academia starting off a young company. Even when and this was the first spin-off from ISC, or from ISC, yes, from Institute of Science, first spin-off. And in fact, there was no framework or rules available for ISC to how to deal with the situation where a professor wants to also run a company while teaching. So they also, in a way, were pioneers and laid the path for future, entrepreneurs who had academic background. Can't agree more. I mean, fully endorse that. Yeah.
Thank you.
Thank you, sir. If there are any further
Thank
questions,
you,
happy to
Anindya,
take.
sir.
Otherwise, yeah.
Yes, so we do have a lot of questions here. So Pankaj Saha is asking, what are the drafting and filing costs for a US patent for a small investor or individual?
Yeah. So typically in US, if you're filing for the first time, you will qualify as a micro entity, which means you pay a very small nominal government fee of, I would say maybe around $250, $300, roughly speaking. That's your government fee. Unless, of course, you have large number of claims and large number of pages, but typically $300, $400 for the government fee. Then, of course, drafting is the biggest component of IP work, especially on the patent side. My own experience, I'll tell you. Typically, for a young company, for a US patent, the entire process will be spread over, let's say, 3 years, and they may have to budget for a young company, maybe around, I would say, maybe around 6 lakh rupees, very roughly. That would mean about, I would say, about maybe 1.5 lakhs upfront filing, around lakh maybe. And then after 1.5 years, they have to budget another maybe around 3.5 lakhs. And at the last stage of grant, they have to budget another maybe about 1.5 lakhs. So roughly, very roughly, average for a young company eligible as a micro entity under US patent law, have to budget around 6 lakhs is what I have seen. Now, this is with the assumption that you are using an Indian attorney for most of the substantive work on drafting, and the US counsel is used essentially for a little bit of vetting of the documents and then filing, because the filing can be done only by someone who is a US registered US patent agent. So somewhere you have to involve that. But if you're leveraging Indian attorneys for a lot of backhand work, then about 6 lakhs is what I would suggest you may want to budget roughly for a patent in US.
I hope that is clear. We have another question from Subramanian N, who's asked the same question twice. I missed it the first time. So he says, can you please explain about the SIPP scheme?
Yeah. So SIPP scheme was released by the DPIIT, the concerned department under the Ministry of Industry and Commerce, which oversees the operations for the patent office. Now, under this program, the idea is that young companies, one of course, startups and all, will obviously have to, I mean, will be paying a limited amount of fee for filing and obtaining patents. Also, there are list of Indian patent agents which is made available on the patent office website, and these are the Indian patent agents who have made themselves available to do the drafting and prosecution work for anyone who wants to take their assistance, and they'll be fixed very nominal attorney fee that these people will charge, and the money will be reimbursed to them through the government system. So that's the kind of a program which has been developed. It has mixed views, but of course some companies are able to make good use of that opportunity. Yeah.
Thank you, sir. There are a couple of questions more, so if you'd like to take them.
I can take, I mean, I don't know if you have a follow-up session. I don't want to be,
So
but
this is
otherwise,
the last session
sure.
scheduled for today,
Okay,
sir,
so I'm
and
happy to
this is the
take.
time for the question.
Go ahead, go
Okay.
ahead.
So Rakesh Kumar Chaudhary has asked that if someone has missed the opportunity to file the NCT in time, then is there any other way to get a patent abroad?
Uh, this is NCT or PCT they meant? PCT maybe. I
or
think PCT is what they meant.
PCT?
Yeah.
Yes.
Yeah. So they're saying if the PCT has been missed, then can they file something, right? That's what I think the question is. Look, so what happens is that, the PCT is one option, but there are other options also by way of which you can file applications. So for example, let's say your interest is in two countries, India and US. You have filed in India. Let's say you're based in India. Your first immediate priority was India. You have filed in India. Then law says that if you are able to, let's say, file in your other country where you had commercial interest, that is US, if you're able to, let's say, file it within 1 year of filing of your Indian application, then you can, of course, successfully have a US application filed, and the US application will enjoy the priority date of the Indian application which you had filed earlier. So the two applications will get linked. So that is one option for you to enjoy the priority date of India case and still have a subsequent application in US. Now there could be scenarios that where you want to add more countries. You can, if you want to also along with US add China and Australia, then your deadline is same 1 year for all these three countries from the time you file the Indian application. Now there are 2-3 nuances that I'll briefly touch upon and not go too much into detail, but 2-3 other nuances are the following. One, as you might know, every patent application gets published after 18 months from the priority date or earliest filing date. So your Indian application, in the scenario I mentioned earlier, your Indian application will get published in 18 months, immediately after 18 months. So which means that if you are for some reason not able to file application in US and China and Australia within that 1 year, which I had mentioned, then you still, theoretically speaking, have another 6 months because your Indian application is not yet published. So even in that 6 months period, you can still file in those countries, but you will not enjoy in such cases a priority of the earlier filed Indian application, because that priority claiming ability was available under Paris Convention only up to a year's time. That is one thing you need to be mindful of. And then of course there are issues that if you're using that additional window of 6 months that I've just now mentioned, then you also have to ensure that you have already not made the disclosure of your invention in the public, because if you have done that in the interim, then the novelty aspect of your technology is lost. And once the novelty feature is lost and you're not enjoying the priority of your Indian application, then later your own public disclosure of your own invention can become a prior art to question the credibility of your subsequently filed applications in US, China, and Australia. So these are a few nuances you have to keep in mind. But yes, beyond PCT, there are mechanisms available with certain time constraints. Yeah.
Perfect. Thank you so much, sir. I think we have one more question from Disha Soni, who is asking, are startups from other countries also eligible for exemptions such as lesser fees, etc.?
Yes, yes. So those features are available for foreign companies as well. There was some ambiguity earlier. Things were not clear, but yes, the foreign companies are also able to avail some of the benefits, not all, but some of the benefits.
Perfect. We'll take one last question, sir, and then we
Sure,
can move to your concluding remarks.
sure.
So Ronak Jaisinghani asks, how can startups access existing patents to enhance their capabilities using inventions that complement their work?
Yeah. So, as the previous speaker Bindu also indicated, there are databases that you can make use of. Like she, I think, talked about PatSeer kind of a tool. There are several databases freely available that you can make use of. I would strongly encourage you to start with something like US Patent Office website, uspto.gov. As you might know that um, globally, whatever number of inventions are filed across the world, almost 65-70% of those inventions sooner or later do get filed in US. So think of it, if you're able to do a decent search on US Patent Office website, and it's a very user-friendly tool, then you will get a good idea about what kind of patents have been filed in a particular area of technology which is of interest to you as a startup. So you can input keywords. There are different ways and means to do nice searches. You get good hits, and that can give you enough background information about what all work is been done, let's say in a particular scientific area, so that you also have an idea that in which direction you want to head as a startup or as an inventor or a researcher. So a lot of that knowledge, stock of knowledge is available through, for example, USPTO, and similarly European Patent Office also has a very good user-friendly database. If you're using these two, they all are in English language, and that will give you a good amount of background information.
Perfect. Thank you so much, sir. I hope that answers. So I request you to give your concluding remarks, if any.
Sure. So thank you so much again to all of you for your patient hearing. Really enjoyed interacting with you and taking these questions. And again, a big thank you to Dr. Anindya Sirkar and to NALSA for making me a part of this initiative. And I would love to continue this engagement going, and looking forward to interact with you and hopefully more in person in Hyderabad and other places. Thank you so much. Really appreciate it.
That'll be a great opportunity for us as well, sir. Looking forward to it.
Thank you so much.
Uh,
And I log off now. Yeah.
yes.
Thank you so much. Take care.
So I thank all the panelists and all the attendees for joining in with us for today's session. So as you're all aware, that we have a sixth panel session tomorrow as well. So do log in at the designated times tomorrow as well. And I hope to see you all with the same energy and enthusiasm tomorrow. Thank you all. Have a great day.